Most drivers in America believe something that simply is not true. They believe that if they are polite, calm, and cooperative during a traffic stop, the law will protect them, that the system is built on fairness, that if you haven't done anything wrong, nothing bad will happen. After years sitting in courtrooms, watching hundreds of body camera videos, reading transcripts line by line, and arguing suppression hearings where every word spoken on the roadside gets dissected under fluorescent courtroom lights, I can tell you something uncomfortable. The law on paper and the law on the side of the road are not always the same thing. And in 2025, the gap between those two worlds is getting wider because new DMV enforcement policies, expanded traffic statutes, automated detection systems, and updated roadside procedures are changing the way traffic stops unfold across the country. But beneath all of those changes, the new distracted driving enforcement, the expanded license suspension triggers, the digital registration systems, the automated plate readers, there is one phrase that matters more than anything else a driver says. One sentence that sits quietly at the center of almost every suppression hearing I have ever argued. The phrase is simple. I'm not answering questions. Now that might sound confrontational. It might sound rude. It might even sound like something only criminals say. That's what people assume the first time they hear it. But here's the reality that surprises most drivers. That phrase is not aggression, it's not defiance, it's not disrespect. It is the single most legally protected boundary a citizen can draw during a traffic stop. And the reason that phrase matters so much in 2025 is because traffic enforcement has changed in ways most drivers have not caught up to yet. Modern traffic stops are no longer just about speeding tickets. They have quietly become one of the primary entry points for criminal investigations. Let me explain what that looks like in real life. You're driving home after work. Maybe it's late. Maybe you're tired. You see flashing lights behind you. Your stomach tightens the way everyone's does. You pull over, hands on the wheel, heart beating a little faster than usual. An officer walks up and asks a question that sounds harmless. Do you know why I stopped you today? This is where most drivers step into the trap. Because the question feels conversational, friendly, almost casual. But legally, it is not casual at all. It is investigative. The moment you start explaining, guessing, apologizing, you are doing something that the Constitution never requires you to do. You are building the state's case for them. Now, this is the part most people misunderstand. Officers are allowed to ask questions during a traffic stop. Courts have repeatedly upheld that practice under what's called a Terry stop, stemming from the Supreme Court case known as Terry vs. Ohio. That case created the legal foundation for brief investigative detentions when an officer has reasonable suspicion of a violation. But here's what that ruling did not do. It did not require you to answer questions. Your obligation as a driver is extremely limited. In most states, you must provide identification, registration, and proof of insurance when requested. That's it. Everything beyond that becomes voluntary conversation. And voluntary conversation is where things start to spiral. Let me give you a scenario I've seen play out more times than I can count. The officer asks where you're coming from. You say you're coming from dinner. The officer asks if you had anything to drink. You say, just one. Now understand something important here. The officer didn't need proof of intoxication. The officer needed a reason to continue investigating. And just one drink is often enough to justify roadside sobriety testing. This is where it turns. Because what started as a routine speeding stop is now becoming a DUI investigation. Body camera footage later gets played in court. Your words get replayed, your tone gets analyzed, the timeline gets reconstructed, and suddenly that small, polite answer becomes the cornerstone of probable cause. That's why the phrase matters. I'm not answering questions. Not because it's magic. Not because it stops the officer from doing their job. It doesn't. But because it prevents you from unknowingly expanding the scope of the stop. Here's where the 2025 changes start to matter. Across the country, DMV enforcement policies are increasingly tied to automated data systems. License plate readers, insurance databases, registration status verification, and electronic warrant checks all happen within seconds now. Officers no longer rely solely on visual observation. The system feeds them information instantly, which means something subtle has happened during modern traffic stops. The officer often already knows a great deal before they even reach your window. And that's why conversation becomes the investigative tool. Questions about where you're going, who owns the car, why you're in that neighborhood, whether you've had anything to drink, whether there's anything illegal in the vehicle. Individually, each question sounds harmless, but collectively, they build narrative, and narrative is what prosecutors rely on in court. Let me be honest with you. When I review body cam footage with a client, the moment I'm usually looking for is not the moment the officer found something. It's the moment the driver started talking, because that's where the legal defense begins to weaken. Now, some people hear this and immediately ask the obvious question. Won't refusing to answer questions make the officer suspicious? Yes. And this is the hard truth most people don't want to hear. Asserting your rights can make the encounter more uncomfortable. The officer might take longer writing the ticket, the officer might call for backup, the officer might speak more sternly. That discomfort is real. But discomfort is not the same thing as legal vulnerability. Your constitutional protection against self-incrimination exists for a reason. It comes directly from the Fifth Amendment, reinforced repeatedly in cases like Miranda versus Arizona. You are not required to build a case against yourself. But here's where things get complicated. Traffic stops operate in a legal gray zone that most drivers never think about. They are technically temporary detentions, not arrests, which means many of the formal protections people associate with criminal procedure don't activate immediately. You may not hear Miranda warnings. You may still be asked questions, and officers are trained, quite professionally, I might add, in conversational techniques designed to keep people talking. This is not misconduct. It's standard investigative practice. Officers are taught that people often reveal useful information simply by filling silence. Humans are uncomfortable with quiet. Silence feels awkward. So drivers start explaining things that were never asked. I was just speeding because I'm late. I had one drink, but I'm fine. My friend borrowed the car earlier. Every one of those statements has appeared in courtroom transcripts I've read. And every one of them made the defense harder. Because once words are spoken, they exist forever in the record. Here's the phrase again. I'm not answering questions. Notice something about that sentence. It doesn't accuse the officer of wrongdoing. It doesn't argue. It doesn't escalate. It simply establishes a boundary. You are complying with the legal requirements of the stop while declining voluntary interrogation. That distinction matters. Now, some officers will respond by shifting tactics slightly. They might say something like, if you have nothing to hide, why not answer? This is the trap, because the question reframes your constitutional right as suspicious behavior. Psychologically, that pressure works extremely well on most people. Nobody wants to look guilty, so people start talking again. But the Constitution was written with exactly that pressure in mind. Rights are not contingent on appearing innocent. They exist specifically to protect people when suspicion already exists. Let me tell you about a case I handled that illustrates this perfectly. A driver was pulled over late at night for a minor lane violation. Body cam footage shows the officer approaching calmly, asking routine questions. Where are you coming from? The driver says a friend's house. Where were you before that? The driver hesitates and says a bar. The officer asks if he had anything to drink. Just 2 beers. That was the turning point. Field sobriety tests followed. Then a breath test. The driver's blood alcohol content was just barely over the legal limit. In court, the prosecution relied heavily on the driver's own statements. Those admissions became part of the probable cause analysis that justified the tests. Now imagine the same stop with one difference. When asked where he was coming from, the driver says calmly, I'm not answering questions. The officer can still run license checks, still issue the ticket, still observe signs of impairment if they exist. But the entire evidentiary chain looks different. No admission, no narrative, just observation. That difference matters enormously in court. Now let's talk about something few people discuss. The physical effects of a traffic stop. Adrenaline. Your body treats flashing lights behind you as a threat signal. Heart rate rises, hands shake, voice changes. Even innocent people display nervous behavior. And unfortunately, nervous behavior often gets interpreted as suspicious behavior. That's not because officers are malicious. It's because they are trained to look for behavioral cues associated with criminal activity. But adrenaline affects everyone. Your brain is not operating at full clarity in that moment, which is exactly why rehearsed boundaries matter. I'm not answering questions. A calm sentence you've already practiced saying. Because under stress, people default to habit. Here's another thing drivers rarely think about. Body language. Officers observe movement constantly during a stop. Hands disappearing from view, reaching around the cabin, sudden gestures. These things raise safety concerns immediately. Keeping your hands visible on the steering wheel is one of the simplest ways to reduce tension during an encounter. Slow movements, calm tone, neutral posture. And if you use the phrase, use it the same way you would speak to a colleague or a neighbor. Calmly, not defensively. I'm not answering questions. No sarcasm, no attitude, just clarity. Now, sometimes people ask what happens if the officer keeps asking anyway. It happens. In that situation, the best response is consistency. Repeat the phrase, I'm not answering questions. You are not required to improvise legal arguments on the side of the road. Your goal is not to win a debate. Your goal is to preserve your rights for later review in court if necessary. And courts review these interactions very carefully. Suppression hearings often hinge on whether statements were voluntary, coerced, or the product of prolonged questioning beyond the scope of the stop. Your silence creates a clean record. Now let me be honest with you again. This approach will not always make the encounter shorter. Sometimes it does the opposite. Officers may proceed methodically through every procedural step available to them. That can take time. But time is not the same thing as legal exposure. Talking increases exposure. Silence reduces it. And in the courtroom world where I work, that difference is everything. The law surrounding traffic stops continues evolving every year. New DMV policies in 2025 are expanding enforcement tools in ways that give officers more information faster than ever before, which means the roadside conversation is becoming more, not less, significant. Drivers often assume their protection comes from being polite and cooperative. But politeness and legal protection are not the same thing. You can be respectful without volunteering information. You can comply with lawful orders without answering investigative questions. And that distinction is the quiet line separating thousands of cases that succeed in court from those that fall apart. So if there is one thing worth practicing before you ever see flashing lights in your mirror, it is not a legal speech, not an argument, not a confrontation. Just a single sentence delivered calmly. I'm not answering questions. Because when adrenaline spikes, when silence feels uncomfortable, when a friendly question tempts you to explain yourself, that phrase becomes the anchor that keeps the entire interaction within your control. And if you ever find yourself on the side of the road, heart racing, lights flashing, unsure what to say next, you won't have to think about it. You'll already know the words. I'm not answering questions.